Hi, welcome back. I'm Derek Watkins, an experienced Mackenzie friend, and today I'm covering part two of dealing with allegations of abuse. Before we get going, I would suggest that you press the subscribe button below if you find these videos helpful for you. Well, in today's video, I'm covering challenging the need for a fact-finding hearing. Fact-finding hearings are considered in cases where there are allegations of domestic abuse or that there is a risk of such violence of abuse. Now, practice directions apply to the family court proceedings and provide guidance to the court. Practice Direction 12J specifically provides direction in cases with allegations of domestic abuse. It is therefore an important document in such cases as it provides guidance to ensure that the children or victims are safe and the steps that the court should make next. This includes determining the extent in which the allegations are relevant and deciding what the terms should be of child contact arrangements. And a key part of Practice Direction 12J is with regard to determining whether it is necessary to have a fact-finding hearing. A fact-finding hearing may be required when allegations are made by one party and denied by the other party. Very importantly, a fact-finding hearing should only be considered if the allegations are relevant to the proceedings, which I will come back to in a while. So, there is now one party making allegations and the other is denying it. The court does not know which party is telling the truth and therefore needs a fact-finding hearing to determine the true position for each of the allegations made, i.e., is it factual or not? Now, the family court is different to the criminal court, where a charge has to be proven beyond all reasonable doubt. A fact-finding is based on the balance of probability, i.e., both parties start at 50% each, and the matter only has to swing by, say, 1% to 51% for the balance of probability to be in that party's favour. Fact-finding hearings are typically 1 to 5 days long, depending on the number of allegations made and number of witnesses to take part. A fact-finding hearing will delay the process by around 5 months, which also means delaying any progress in terms of contact with your children by 5 months or more. It is therefore in your interest to try and avoid a fact-finding hearing if at all possible. I covered a fact-finding hearing in my next video. However, today we will look at how we can best challenge the need for a fact-finding hearing. Now, unfortunately, the courts have got into a habit of ordering a fact-finding hearing as soon as allegations of abuse have been made, without determining whether it is necessary or not. And as a result, they've been handing out fact-finding hearings like confetti. As mentioned, a fact-finding hearing can be anything from 1 to 5 days long, and are typically 2 to 3 days long. This has totally clogged up the family court, resulting in a huge backlog of cases and why you have to wait so long for your hearing. As a result of the strain that the fact findings are having on this system, in May last year, Sir Andrew McFarland, the President of the Family Court Division, issued new fact-finding hearing guidance to judges and magistrates. The aim of the guidance is to reinforce the judges and magistrates that they should analyse and determine the necessity for a fact-finding hearing and only order one if it is necessary for the welfare of the children. In other words, stop handing out fact-finding hearings like confetti and do your job properly. There are some very interesting statements in this guidance, which I'll run through now. Number 1. As the judge or magistrate, you have the expertise and relevance to determine the necessity for a fact-finding hearing. The views of the other parties, and more importantly, the CAFCASS officer, may be persuasive. However, interrogate their reasoning. In other words, the judge should not just order a fact-finding hearing because the CAFCASS officer has recommended that the court should consider one. The judge should, in Sir Andrew Macfarlane's own words, interrogate the CAFCASS officer's reasoning. Wow, that would be a first. The guidance also states there is a time and a place to determine allegations of abuse, but it may not be in your court. Do not allow your court to be used to litigate such allegations unless it is relevant and necessary in your decision regarding the welfare of the children. In other words, don't get caught up in matters that should not be yours. Only order a fact-finding hearing if it is really necessary. And it gets even better. Identify the real issues in the case. Is one parent denying contact or seeking to add conditions for contact arrangements? Of course they are. It has been happening for ages, and about time the court got wise. Consider if the extent of the allegations are likely to be relevant to make the child arrangements order. Always consider if the allegations, if proven, could be mitigated by supervision of contact. Why then is a fact-finding hearing required? Wow, this is gold dust. So, how much of a difference has this made in determining the need for the courts to order a fact-finding hearing, you may be thinking? Well, Sir Andrew Macfarlane's guidance was provided last May. And I can tell you that I've been involved in numerous such hearings since then. And it has not made a jot of difference. The courts still have that fact-finding hearings like confetti, as they are too busy or can't be bothered to seriously question and analyse the need for one. I have only had the pleasure of one judge that actually applied the guidance properly and explained his reasoning for not ordering a fact-finding hearing and actually referenced the guidance. Well, what can we do? Well, we can remind the court in the nicest way possible of what their obligations are as per Sir Andrew Macfarlane's guidance. We will reference it in your position statement and point out the relevance of its key points to your actual case, seriously questioning the necessity of a fact-finding hearing. We will also prepare well for your hearing, where you again question the key points and relevance in court. We will not just sit back any longer and have our time with our children delayed by a further 5 to 6 months. We will stand up and take action. Well, in my next video, I will cover the fact-finding hearing and how we show your ex as the malicious liar that she really is. So, stay tuned and press the subscribe button below so you are notified of when this video is published and available for you. And if you'd like further assistance or discuss your particular case, then go to www.mackenziefriendconsultants.co.uk and book your free consultancy with me. So, bye for now, and stay tuned for my next video. Thank you.